How's it going, landlords? I hope you are having a great day. I'm happy to be joining you this afternoon while we are talking about that non-paying tenant. If I've got a non-paying tenant, how long do I have to wait before I can kick them out? And I know that's something that happens a lot because we deal with that a lot. And so if you are in a situation where you've got a non-paying tenant, I'm going to give you some tips on what you need to consider in order to effectively get rid of this tenant. And so let's stick all the way to the end. I've got multiple points that I want to share with you. And then I'm going to get to the questions that we have. Now, I've got a list of questions here where I've, pre-screened them and answered them, and we'll share those answers with you. But if you have a question and we're unable to get your questions in, I welcome you to add those into the chat. I look forward to answering those questions for you live here. And of course, if you missed it, you can catch us every Wednesday at 4 p.m. Houston time. So I look forward to answering your questions and kind of filling in my thoughts on today's topic. So again, just as a reminder, if you're not part of our mailing list and would like to be, I would recommend that you send us an email at info@attorneyeg.com. That's info at attorneyeg.com. Hey, James, good to see you again, as always. And simply request to be on our regular newsletter for our law firm. If you are not part of Texas Landlords and you are a landlord in the state of Texas and would like to be, that's our Facebook group, Texas Landlords. And so we draw questions from people replying to our newsletter. We draw questions from our Facebook group. And then, of course, we handle anything that we get here live. So let's get to it. So, when you're dealing with a non-paying tenant and you're wanting to get rid of them, you're probably at that boiling point where you just had enough and you want to make sure that they are out. So the first thing that I want to cover with you is the fact that you at no point in this process, at no point can you physically remove a tenant. It doesn't matter if you've given them a notice to vacate. It doesn't even matter if they are beyond the date specified in their lease. Sometimes landlords come to me and they'll say things like, hey, Ernie, their lease is about to expire. Can I grab their stuff and put it out on the curb the day after the lease expires? And the answer is an absolute no. There is a process to physically remove the tenants from your property. And again, the fact that date has come and gone is not the only part of that process. In fact, that's almost a non-factor if you haven't followed all of the steps required by your local jurisdiction. So I want to get into those next. The second thing you're going to want to consider is, what does your jurisdiction say in terms of how soon you can even begin the process? Because, and here's just the long and short of it, you can't expect the courts to help you out when your tenant fails to follow your lease if you didn't follow the law. So make sure you understand what your jurisdiction requires. So let me give you some examples that are Texas specific. If you're in Texas and you are a property owner and you rent out lots for trailers, so people park their trailer on your lot and you do a lot rental agreement. And so it may seem intuitive that, well, they only paid half a month's of rent this month, and so I am going to evict them. Well, in Texas, you can evict someone from their lot rental if they owe less than 1 month of rent. And so if you don't know this, you might approach this differently, and you might show up to the court and get turned around and get your case dismissed because you simply didn't follow what that jurisdiction requires for that specific type of rental. Now, in a single-family home, that doesn't apply in the state of Texas, but certain states require that rent be unpaid, or that a certain amount of rent or certain percentage of the rent be unpaid before you can begin the process of handing over somebody a notice to vacate. So let's see. Chand Prabha says, How should a landlord handle it if the tenant just sends a message on the last day of the month saying that they left and they're leaving tomorrow morning and they're not going to pay any more rent? Well, that's a different situation because you don't have to remove them. If they are in fact abandoning the leasehold, certainly you've got, the security deposit in place, but that's probably going to go to damages that they've left. Hopefully they haven't left any, but if you're in a situation where your tenant has just abandoned the leasehold, the main thing is you got to mitigate your damages as quickly as possible. And Chand, I appreciate you asking the question because this does also happen. And so by mitigating your damages, you go in, you reset the unit, you get it ready for the new tenant, and then you put it on the market. Now, remember, you're going to want to make sure your tenant has actually abandoned the unit. And your lease might have a protocol for you to follow in the event of abandonment, where you put a notice and you wait a certain amount of time. And if that's the case, that they've just told you, I'm leaving, and they've in fact taken all of their stuff, then you can pretty well understand that they've abandoned the lease and taken all their things with them. So yes, the next best thing would be calculate your damages. Hopefully the security deposit is enough, but definitely try to put another tenant in place. It may turn out that you find a tenant within 3 or 4 weeks. And so all you've really lost is that 1 month. And if the security deposit covers that month, you may actually have no damages. Now that's things working pretty quickly, and it's not always the case, but hopefully that's the case for you. The best thing you can do is act quickly to mitigate those damages. Gosh, I'm thirsty today. All right, James asks, if I have a tenant who is behind on the rent and in violation of the pet policy, among other issues, I want this tenant out and don't want her to cure the situation. I just want her to leave. Can I? Yes, actually, specifically with the issue of non-payment of rent. Now, I know that in some jurisdictions, if a tenant is delinquent in non-payment of rent, some jurisdictions require you to accept rent if you've given notice. And so in those jurisdictions, they tend to require a pay or quit notice. So it's like a notice to vacate if you don't pay. And so you kind of can't work around that element of the law. But if you're in Texas, that doesn't exist. In Texas, you can make an unconditional demand for possession. And even if they show up with the rent later, you're not required to accept it. You can simply proceed as long as you've delivered proper notice and you have a valid basis. Now, between me and you, James, and I see that you're in Texas, between me and you, the problem with this is some judges don't always follow the law. And so if you've got a pet violation included that has not been cured, even if the tenant shows up with rent at the trial setting, you can say, look, they've got multiple violations. I've listed them all because of this multiple violations, including the non-payment of rent, which, okay, they're showing up with it now, and I'll take it now and take a $0 judgment, but I want possession of the property. And so I would insist on that, even if you've got a very lenient judge, but be cognizant of that fact. If all the matters are cured, the judge is, he's got it within his or her power to make a rogue ruling. You say, do I have to list all the violations in the 3-day notice? The property code doesn't require that you list them all. I strongly suggest it. I think it's a good CYA approach of giving good notice. Now, I've only had one judge in my 15 years ever call me on that, where he claimed that I hadn't notified everyone of all claims. And so he almost ruled in the favor of the tenants. I was able to argue my way around it, but because the judge mentioned that, from that point on, I have made it a rule in my office that if we know 10 claims, we list 10 claims. So all of them are there every time, so we don't have some judge come up with this new reading of the law requiring that they all be mentioned. In Texas, all that's required in your notice to vacate is a demand for possession. And you have to have a valid reason for it. It doesn't say it has to be exhaustive of all claims. That's simply not the way the code is currently written. So You understand that your rights are limited to what the court will allow. Second, you know when your jurisdiction allows you to issue your notice if you're looking to get rid of a non-paying tenant. The third thing that I recommend is for you to know, what the rules are for your notice to vacate. We've had a few questions, and James, you're very welcome. We've had a few questions having to do with notices and, when these things trigger. You want to know, is it appropriate to send, in Texas specifically, a 3-day notice, a 10-day notice, or a 30-day notice? And if you don't know the differences between these notices or when they kick in, you're probably going to want to talk to a professional. And no, I'm not going to talk about the varying lengths of notices, having to do with, each of the 50 states. I'm certainly not going to do that because I don't know them for each individual state, but I do know that, for example, in Texas, if you don't have a lease or if your written lease doesn't include attorney fees, but you want to collect attorney fees, you got to give a 10-day notice at least. I also know that if you've got a federally backed mortgage, or if you're accepting federal funding for maybe Section 8, you need to give a 30-day notice because the old CARES Act from 2020 is still in effect with regard to eviction notices. So if you have none of those factors, then in Texas, the default is a 3-day notice. Now, I know some of you are thinking, well, Ernie, my lease allows me to give even less. I can give as little as a 1-day notice. And while that may be true, I always warn landlords that extra couple of days isn't really going to bring you much harm. But because I have seen judges say, I don't honor anything less than 3 days, it's our rule in this office, every notice to vacate is at least a 3-day notice. So make sure you understand the rules of your jurisdiction and the kinds of things that are likely to pop up if you're going to file. So Chand says thank you. You're very welcome, Chand. Number 4, if you have filed, do you have a final judgment? And so sometimes people file and believe that because the matter is going to court, they can walk in and they can start bossing the tenant out and maybe grabbing their stuff and moving it out for them. I don't recommend that you as the landlord interfere in any way. The fact that you do or don't have a final order is itself not the end. Because let's say, in fact, you do have a final order from the judge. That, in the state of Texas, is still not enough. In fact, in most states, you're going to need to go on to step 5, which is the purchase of a writ of possession. If you want them out, but they refuse to leave, again, you can't put your hands on anybody. You need the permission of the court. And the step after a final judgment is to seek out a writ of possession. In the state of Texas, it's about $130, $140, depending on the county where you are. But you purchase a writ of possession after a final judgment so that the court can authorize the constables or the sheriff, not you, it's someone in law enforcement, either the constables or the sheriff, to go and they can physically remove people from the property. And that's the last step. Until the tenant actually vacates voluntarily, or until the constable or sheriff comes in and physically removes them, then you can say you have actually kicked them out. Right? You don't ever want to take it into your own hands. You don't want to do a self-help method of grabbing their stuff and moving it out yourself, or taking your drill and taking the door off the front because you've given them a notice to vacate, and that's going to be pretty persuasive if they don't have a front door that you want them to leave. The law does not allow you to do that. So you can neither, render the home uninhabitable. I've heard stories of landlords going and, disconnecting the AC and saying, well, you're not going to have AC for a while. I just disabled it. That's not good. Turning off electricity, also not good. Believe it or not, removing the front door. Again, you don't want any of these self-help remedies because the courts are set up to protect both the rights and, the privileges of being a landlord, but also the rights of a tenant. And so they'll stand in the middle for you if you follow the rules. And so the last of which is let the county, the sheriff or the constable or whatever, law enforcement official in your jurisdiction handles these. Let them remove the people. You can go in there and take possession once that's occurred, but don't jump the gun. I see a lot of landlords put themselves in compromised positions and sometimes get their evictions turned around and kicked out because they acted too quickly. Make sure if you really want them out, you know what the law requires and you follow the law to the letter. So that's my 2 cents on non-paying tenants and how to get rid of them through the legal method. I see James adds, can I give 5 days with a 3-day notice? Yes, absolutely. What the law requires in Texas is no fewer than 3 days. So let's say you give a 3-day notice, but you don't act on it until 5 or 6 or 10 days later. That's not going to affect the validity of the notice. Now, if you give a 3-day notice and don't do anything for 90 days, but during that interim, you've accepted rent, chances are very, very likely that notice is of no effect. If you've waited an extended period of time and accepted rent, you've probably invalidated that notice. So no, there's no, absolute end date where your notice to vacate is no longer valid. But you're going to want to, if you say 3 days, you're going to want to do it as soon after that as possible, so you don't have some claim that you've invalidated your notice by course of performance. So, but certainly a couple extra days is not a big deal. All right, so let's get to our questions. First question is from Alexander Valentin. He said, here's the scenario. A pipe leak knocked out the only shared common bathroom in a 4-bath, 2-story home. So there's already 4 bathrooms here. One of them gets knocked out. The tenant works from home and has access to all other bathrooms, but guests are forced to go upstairs through the private areas, and the restoration was estimated originally at 10 days. But now it's been 20 and the work just started. So it's been 20 days, absolutely zero use of that bathroom. The tenant has been home, or the tenant has to be home for inspections and is frustrated by the disruption. Here's my simplified approach. Monthly rent is $4,000. Daily rent is about $133 a day. The common bathroom is estimated at 6% of the rent. That's $240 per month or $8 a day in rent credit. So $8 a day times the total days without use comes to what is probably their loss. The landlord's repair costs would be over $7,000. Not an issue for the tenant. But do I have to, in my method, account for, quote, inconvenience, time lost, or disruption beyond the basic utility value? And the short answer is nope, probably not. Because there's nothing in your lease that says that you ensure that your tenants will be without inconvenience, without loss of time, or without disruption. The truth is every repair has some inconvenience, loss of time, and disruption. But, the fact that you fix the thing in 1 day or 2 days doesn't mean they're entitled to any money for those days. In this case, you might have a diminished value that's more significant. It's a bathroom. And so it would be fair to reduce the rent, in this case, by $8 a day until the work is completed. But the law actually allows delay in the process. But what's required of the landlord is diligence. Did you act with diligence throughout the process? That's what makes, this method of calculation pretty fair. And so if you acted with diligence and you did everything that a responsible landlord would do to get this done as quickly as possible, including filing a claim with your insurance company, there's nothing wrong with waiting for the insurance company to give you, confirmation that they're going to cover this claim if that's how you're paying for it. In fact, the law specifically addresses that when it comes to delays. But in terms of inconvenience, time lost, and disruption, that's what renter's insurance is for. And hopefully your lease has, like my lease does, or any good, a well-drafted lease, it has an indemnification clause that says, look, I'm not going to be held liable for something that happens to you unless I was somehow grossly negligent and maybe even caused the thing. And we presume that, you didn't go and, snap that pipe and I'm going to ruin the bathroom. I'm presuming that didn't happen. And so because this occurred, this casualty event, that's not on you, and your lease should clearly say that. Secondly, your lease should, I know the lease that I draft does, require that your tenant purchase renter's insurance. In this event, the purchase of renter's insurance would have been great because they probably could have made a claim against that insurance. In fact, they might have been able to be put up in a different residence, depending on the extent of the loss. But they might be entitled to money damages to compensate them for these issues, right? So the last consideration is whether or not your lease allows them to use the home for a business purpose. Now, I'm not exactly sure what you mean by she works from home or this individual works from home, but I don't know that that's necessarily allowed under the terms of your lease without reviewing that lease. And so if she's doing something that's otherwise prohibited, she can't be compensated for that. And so, but these other things, kind of just the disruption and what have you, again, I believe that's a claim she can raise in the through the renter's insurance policy, but it's probably something that is waived in the lease if you have an indemnification clause. So, Alexander, hi, Ernie, the tenants and accountant. Okay. Well, again, I don't know if she's seeing clients or whatever. If your lease prohibits business activity, certainly you don't want her seeing clients that actually could have an impact on your own insurance for the property if it's being used as a satellite office or a business. But in this case, I think you should look to see, do you have an indemnification clause? Do you have a clause in your lease that talks about casualty events or events of damage and your liability? You may have a liability paragraph that addresses these issues quite clearly. I would look for that in your lease. I think what you're offering is a very fair offer in terms of, the calculation that you've prepared. So, Alexander, I hope that helps. Jeremy writes, in Texas, does a property manager have to be licensed in order to manage a rental property for someone else? They draft and sign a lease, show the property, etc. Okay, so this is going to depend on who that someone else is. If that someone else is a member of your family, then you're probably okay. But if it's someone who's not part of your family, you absolutely do. Listen to this. An individual can manage his own property, or the property of family, but only a licensed person can lease real property, offer real property to others for lease, negotiate a lease, list the property for lease, collect rent or deposits for another person in exchange for money. So usually if you're doing it for your family, you're probably not hired by them. If you're helping out your mom and dad, that sort of thing, you're probably not being paid a fee. But if you are being paid a fee and and it's not your own property, yeah, you're going to need a license to do work like that. I don't recommend it. Here's what the law says. This is, unless a person holds a license, I think this is out of the, I forgot to write down what section of the code this is. I think it's the occupations code, but it's 11.01.351, license required. Unless a person holds a license issued under this chapter, person may not act or represent that a person is a broker or sales agent. And it defines what a broker is, and it's somebody who represents somebody else. Here's the actual definition. A person who, in exchange for a commission or other valuable consideration, or the expectation of receiving a commission or other valuable consideration, performs one of the following: sells or leases real estate, offers to sell or lease real estate, negotiates or attempts to negotiate the listing, sale, or purchase or lease of real estate, lists or offers or agrees to list real estate for lease, or finally controls the acceptance or deposit of rent from a resident of a single-family residential real property unit. So yeah, if you're going to be doing any of these things and you're not a licensed realtor licensed in the state of Texas. It's technically not legal. I do not recommend it. Of course, it's your own property. By all means, you are free to do it. Close family, again, as long as you're not getting paid for it. Here we go. Vandale Gentry from our newsletter says, hey, Ernie, in your recent video, your tenants are robbing you blind. Now on YouTube. Go check it out. Well, not right now. Finish watching this video. You mentioned, Ernie, that properties often get destroyed because, quote, some parents let their kids run amok. I did say that. I wanted to ask, if a child has a disability, such as autism, does that change your opinion? Or do you still feel that the parent should be able to maintain control over their child regardless? It does not change my opinion in the least. I do still believe that parents are still required to maintain control. This is also true of pets. It's also true of guests, right? If you invite, your Uncle Charlie, and Charlie gets a little bit drunk and he sets fire to the kitchen, and he's like, well, that's Charlie. He's just that way. No, that's not what matters. What matters is that the tenant assumes responsibility for whatever guest or occupant, whatever harm that the guest or the occupant does that is over and above normal use or ordinary wear and tear. So if that occurs, even with a child with a disability, even with an adult with a disability, it's still technically the responsibility of the tenant who signed the lease to make sure that the property is not otherwise damaged. And so, no, you don't get a get out of jail free card, because you have a child with autism. While that may be unfortunate, it's not a defense. And so, the tenant would still have liability. All right, next. Alfredo Meneses, also from our newsletter, asks, I would like to know your input on getting out of sticky situations once you're in them. For example, finding out that you have rented to a professional eviction avoidance specialist. We just call them professional tenants, but yes. Or how to avoid tenants leaving without properly cleaning up or fulfilling their responsibilities as per the contract. Well, there's a couple of mechanisms already built into your lease that kind of step in and prevent this in the first place. So with regard to the cleaning and the kind of skipping out on responsibilities, that's what the security deposit is for. Now you're going to want to make sure that you're not diminishing your security deposit over the course of the tenancy because they've done things in the throughout the tenancy. I talk about this a lot. Don't rob funds out of the security deposit to pay for things along the way. If the tenant is incurring charges and fees and damages along the way, you're charging them for that and you're collecting that. Don't touch the security deposit because it's specifically for things like this. Now, let's say you've got one of these professional tenants who knows how to game the system. Well, you have to hold them, but the truth is you have to hold all of your tenants to a very high standard. And if you've got someone who's violating the lease, you got to call them on it with notices. You got to follow up with additional notices. You got to go and check and make sure they're taking care of the place and not wrecking the place and taking advantage of you. The moment they are out of step, you're hitting them with a notice. And if you've compiled a set of notices that amounts to what I refer to as your 3 strikes and you're out, then you can proceed with a notice to vacate potentially. Now, again, it doesn't make sense if you've got these 3 ticky-tack little violations, all of which have been remedied by the tenant. It's got to be something substantial. I always talk about, did the tenant substantially breach and therefore entitle you to recover possession, where a court's going to be absolutely, you win. There's no way I could see things otherwise. Again, you got 3 tiny things, all of which are corrected or were corrected quickly. It's not going to be as good as 3 ongoing lease violations that were never corrected. So, take that with a grain of salt. Bad tenants are bad tenants, and if they stay bad, and certainly if they don't pay rent, I mean that's the big one. So I don't recommend waiting forever before issuing a notice to vacate. And my rule is 7 days. If you haven't gotten everything in 7 days and your jurisdiction allows it, then proceed at that point. All right. Alexander chimed in. Hi. Excellent response, Mr. Garcia. I truly appreciate your insight and guidance as always. Alexander, I appreciate that. And I appreciate all of you who join and contribute through the live and say nice things. That's always nice to hear. Let's move on. Hannah Butts from our newsletter. How long do you give a property manager to find a tenant? Ooh, this is a good question. My property has been vacant for 5 months. I keep getting excuses as to why they're not finding a tenant. I think that I've been very patient, but my patience is running thin. Well, Hannah, unfortunately, this is a very market-specific question. And so you may have a piece of property that is, boom, smack in the middle of the market. It's not too pricey. It's not too low. It's right in the middle. It is an ideal unit, and there's tons of demand for it. In those cases, you're probably not going to go more than 30 days without good prospective tenants coming and knocking on the door and saying, I want in. But if you've got a property that's up here in the market and there are fewer door knocks, it's going to be hard to find a new tenant. Now, is it possible that your property manager isn't doing a good job of listing the property? Absolutely. Is it possible that the property manager isn't, conducting an open house or being creative in the way that they are reaching out to prospective new tenants? And so I can't say whether or not your property manager is in breach of their property management agreement. I don't know what they promised in that agreement, but if they're not taking steps to advertise, I don't know that that's a good relationship. Find out what they're doing. I know you mentioned they've cited excuses, but aside from the things that have gone wrong or the reasons that it hasn't happened, what things are they doing to mitigate those things that have gone wrong? What kinds of things are they doing to go out and find new people? Combined with, again, the general facts of the market. Is your rent super high? Are you in an area that's flooded with rental property and not as many people? I'll tell you that in the state of Texas, there are certain pockets, certain cities that 2 or 3 years ago were very hot, where a lot of properties were being built because the speculation was this is going to continue to grow, and it stopped growing. And so where at a certain point, the market rent was here, once you have more units than you have demand, that rent's going to fall naturally. And if your rent is still priced outside of the market, or if there is a ton of inventory and not a matching demand, those are all factors. So I would get more specific with your property manager. What are those limiting factors, and what is the property manager doing to account for those limiting factors to help put a good tenant in place in your home? So I hope that helps, Hannah. I know it's not the best news, but unfortunately the markets shift. And if you happen to be in one of those areas where the market has gone down, that's unfortunately going to happen. So, and that's it. That's my last question. I see that I think I've addressed everybody who joined online. I hope that all of you have a great week. I know we've got let's see, another week or so. Let's see, next Wednesday. What is next Wednesday's topic? It's the 13th. My tenant appealed their eviction, and I don't know what to do. We will talk all about eviction appeals next Wednesday. But until that date, I do wish you guys the best of luck. And as always, happy leasing. See you next week, James.